All right, Elie, lay out your argument for us.
Yeah, so Dan, in your A block, I believe I heard you say you think Judge Merchan should have recused himself, right?
Correct.
Over what, a $35 contribution?
Not the number. Not the number. The fact that he actually donated to a he'd be bothered to get online and make one $10 another $10
trial judge. Okay, so I'm just saying, just establishing your position. You think a judge should recuse himself for a $35 contribution. I'm saying at the appellate level, at the Supreme Court level, where these people should be held to the highest standard possible, that supporting an insurrection should probably make you recuse yourself from insurrection cases. See, I think the recusal bar should be relatively very low, especially for appellate courts. There are 9 of them. Why is that? Well, it's because if you lose 1 or 2 in the case of Clarence Thomas, you still have 7 others who are perfectly able to adjudicate the case. In this particular situation, just in case you think I am being partisan, if Alito and Thomas recuse themselves from the insurrection-related cases, guess what? The conservatives, the Republicans still have a majority on the Supreme Court. They can help Donald Trump 4-3 just as easily as they can help Donald Trump 6-3. So the question is whether or not we are going to hold these people to a high standard. And I think flying an insurrection flag means that you shouldn't be able to adjudicate insurrection cases.
Dan McLaughlin.
Well, you know, a flag is worth less than $35, I would say. But, you know, look, Justice Alito, as far as recusal is concerned, Justice Alito has 2 fairly useful things on his side, the facts and the law. On the facts, the simple fact is, I mean, the New York Times has sent 4 reporters onto this. The Washington Post not only reported on the case, but dug up reporting from 3 years ago from their Supreme Court correspondent. And everything supports the exact same fact, which is that the flags were flown by Mrs. Alito, not with any involvement of the justice. He says so. He said so all along. And so, you know, in order to say that he's the one doing this, you simply have to throw out all of the evidence we have, everything that they've been able to pick up. And, you know, as far as the law is concerned, there's 2 important points to remember here. The first is, you know, Supreme Court has always said that what matters in recusal, and there's a reason why the recusal statute talks about what's reasonable in assessing a potential conflict, is the actual facts, not merely what people might think or suggest. There's a Supreme Court case from 2002 called Sao Paulo versus American Tobacco, where a judge had his name appear on an amicus brief during the case. And they said, you know, look, this may look as if he appeared as a lawyer in the case, but his name was placed on the brief by accident without his involvement. And therefore, he didn't have to recuse.
But Dan, let me ask you this. Dan, let me ask you this. Would there ever be a case where the actions of the wife would justify recusal? Meaning, I see federal judges all the time recuse themselves from cases based on what their spouse is doing professionally. And it seems to me that, at least in the case of Clarence Thomas, it's kind of a slam dunk, no?
No, I mean, there are situations where a spouse's involvement can cause recusal. There are plenty where it doesn't. And the court has laid out its own standards on that for some years. It was in a memo they did back in the early 90s. They've incorporated all of that into their self-described code of conduct. But, I mean, you know, and the recusal statute deals with spouses as well. If a spouse has a direct financial interest in a case, you know, if, for example, a trial judge is handling a case and their spouse might be a witness, he's reasonably likely to be a witness.
I thought the standard was about even in the appearance of a conflict, but maybe
reasonable appearance, and that is given content. That is given content both by the details of 28 U.S.C. 455 and by the rules and precedents of the court. I mean, there's no precedent whatsoever for recusal in any situation, even vaguely
Elie, go ahead.
similar
I'm sorry.
to this.
Let me
All
let
right,
Elie
so
go.
you guys are clearly going on the whole believing the Alitos about who put up the flag and when and why. I don't believe them. I think the Alitos have already been shown to be liars on this issue. They say that it was direct response to the neighbor with the vulgar word. When you actually talk to the neighbor, they said the vulgar word happened weeks later. Also, the vulgarity doesn't explain the second pro-insurrection flag. So I don't believe the Alitos. I think they're lying.
Thank you for watching. Go to newsnationnow.com to find NewsNation on your cable provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.